Hello, I'm Andrew Flushy. I'm a Virginia traffic attorney. One question that I get from prospective clients, potential clients, that is a little bit frustrating is, how should I plead? Should I plead guilty? Should I plead not guilty? It's a question that I can't answer just off the cuff like that. The problem is that that question depends upon all the facts and circumstances of your case. What I do as an attorney, if you hire me, is we look at all the elements of your case that the Commonwealth is going to have to prove against you, and we see if they can prove them. Because if they can't prove an element, or if there's a question about whether or not they can, maybe one is a little sketchy on their end, then we would definitely want to plead not guilty, because we would want to have to make them do their job and prove it, and maybe they can't prove it, and we might be able to get you found not guilty if they can't prove every single piece of the case beyond a reasonable doubt. But the problem is that I can't know if the Commonwealth has their evidence in your case unless I've looked at all the evidence and talked with the officer and talked with the prosecutor, and then, and only then, will we know what plea we should enter. So the other choice of a plea would be no contest is one. And honestly, in a lot of cases with traffic cases like reckless driving and speeding and things like that, a lot of times the officer will have all their evidence in order. And the case is more of a question about negotiation, trying to get a better result from the prosecutor or from the judge. And in a case where just the judge is involved, in a lot of those cases where the evidence is in order, I would probably advise my client to plead no contest. But that's only after me looking at the evidence and talking with the officer and knowing for sure that they have their evidence in order. Then we would say no contest, because that's saying we've seen the evidence and we're admitting that they have the evidence to prove the charge they've levied. The final plea that normally would get entered is guilty. And guilty is a little bit different from no contest, because what guilty says is, yes, I did what I'm accused of. There's a difference between saying the Commonwealth has the evidence to prove what they're claiming versus, yes, I did what I'm accused of. And so that's the way I like to think about no contest versus guilty. And most of the time, I wouldn't plead a client guilty unless it's pursuant to a plea agreement with the Commonwealth and they're reducing the charge or giving us a really good outcome that we might not get from the judge. So that's just a little taste of the different plea choices and why it's really hard and it's impossible without knowing all the facts of the case and talking with the officer and any witnesses. It's impossible to make a good decision and advise a person about how they should plead. This is why it's super important if you have any kind of traffic case, whether it's reckless driving or speeding or DUI or driving on suspended license, you really need to talk with a traffic attorney. I'm here in Spotsylvania County. I practice in Stafford County, Fredericksburg City, King George County, and the surrounding areas. I would love to speak with you about your case, give you a free consultation, and see what we can do, and maybe give you at least a little idea about what kind of plea might make sense. But of course, we can't know for sure until we talk with the officer and any other witnesses.